My lady, my lords, I don't propose to go back to Turk Hava Ulari. I've already said that it's a case primarily about a different topic, and just for completeness, paragraph 50 makes it clear the plea of acquiescence failed entirely in that case because it wasn't mentioned the grounds of appeal before the Boards of Appeal, which is why acquiescence is a sideshow to the Turk judgment in any event. Now, on Basile, there's 2 points, and I think my lady and my Lord Justice Arnold have got one of the points, which is the General Court correcting, the Court of Justice correcting the General Court. There's actually another one, which is that it's also inconsistent to Milan Friend's second ground.
Do you want to take us there?
Yes. It's Basile. We don't need the Board of Appeal decision. The General Court decision is tab 40, and it's in A3 at tab 40. And the point here, if I could invite the court to go to the bottom of 182 just to get what we're talking about, you see that it's relating to Article 53.2 of Regulation 4094, so that's the right one. If we look at paragraphs 28 to 30, I'll try and do this relatively quickly. The point here is, having set out Article 53 in paragraph 29, in paragraph 30 they say what the argument was. And the argument was, is the date for applying the correct test the date of application of the contested mark, that's the last line of 30, or was it the date of registration, which is the same point as Milan Friend's second ground of appeal. And then paragraph 31, we have the reference to Budvar, including 58, but as my Lord Justice Arnold points out, that's an inaccurate quotation because they haven't got, their fourth point isn't what Budvar actually says in paragraph 58. But reading on to 32, quite a lengthy discussion all about what the correct date is. The conclusion I'll take the court to is at the end of paragraph 33. Contrary to what the first applicant claims, therefore, it's from the time when the proprietor of the earlier trademark is made aware of the use of the later community trademark after its registration, and not on date on which the application for the community trademark is filed, the period of limitation and consequence of acquiescence starts running. So that's contrary to Milan Friend's second ground appeal. It was actually even worse than that because they didn't have any evidence at all in that case. That's what paragraph 34 says. So that's the General Court decision, and then on the Court of Justice decision, the first thing they did was correct the quotation to Budvar. And if any of go to tab 41, page 197, paragraph 53, they've correctly quoted paragraph 58, which they also cite. And for that matter, they also agree with the General Court about the date point in paragraph 55. So that's Basile. In my submission, all the authorities are actually in my client's favour, apart from Ghibli, which stands on its own. The General Court authorities, at the highest, merely inaccurately cite Budvar. At no point do they criticise Budvar or apply some other tests than set out. And as we see from Basile, the General Court's inaccurate citation of Budvar was corrected by the Court of Justice 10 years ago. So, can I then address my own friend's key submission on this, which is whether the court should depart from Budvar. And it's common ground the correct test is the former House of Lords test set out in the practice statement. My own friend referred to it, but didn't actually take the court to any of the Supreme Court's own jurisprudence on this. I'm going to do so.
I think in fairness, we were rather pushing him along by that stage.
Yes, yes, I don't criticise. I was just saying he didn't in fact do it, which is why I'm about to do it.
Good.
And that's Peninsula Securities at A1.2. And it's tab 11. And we don't need very much of this. The speech of Lord Wilson, with whom Lord Lloyd Jones, Lady Arden and Lord Kitchen just spoke, It sets it out at paragraph 49. And I should say Lord Carnworth actually agreed on this point, as we'll see from paragraph 59 of his speech. But getting back to paragraph 49, I'm sure this is quite familiar to the court, so we can just pick up some key points. The first point from paragraph 49 is the importance of certainty in the law, which I very much rely on. One of my learned friends' somewhat paradoxical submissions, he thinks certainty is achieved by changing the law. We say, no, certainty is achieved by maintaining continuity in the law. The next point, F, is the high degree of caution with which the Supreme Court should address a request for departure. There's a quotation from Horton and Sadler. Over the past 40 years, the House has exercised its power to depart from its own precedent rarely and sparingly, never been thought enough to justify doing so. A later generation of law would have resolved an issue or formulated a principle differently from the predecessors. And pausing there, what has my learned friend done to overcome this high degree of caution? And then in 50, we see that it was, therefore, with appropriate hesitation, that Lord Wilson proposed that the court should depart from the test favoured by the majority in the SO case. And there's a number of good reasons. Even at the time, Lord Wilberforce chose not to associate himself with it. Objections to the test, there are no principle placed within the doctrine, consistently criticised for over 50 years. Reasoning behind it has scarcely been defended, and the common law has been limping between the continuing authority of the test in our jurisdiction, its rejection of Australia and parts of Canada. And where is there anything like that in this case? Now, I was also going to show this court a decision of this court in which my Lord Justice Arnold was a member. That's the Tunin case in the next citation. And Tunin was a case where no departure was thought appropriate. And there's a number of reasons for it. My Lord Justice Arnold gave actually 8 reasons. The Master of the Rules confined himself to 2 reasons.
Yeah, the last 2 of the 8 were to a variant of the argument there. For the main argument, it was 6.
Yes, and my Lady Justice Rose actually agrees with both judgments. But going to the actual reasons, I'm not going to spend a whole lot of time on this, but there's a number of them which do have an analogy to this.
To put this into context, there were 25 judgments of the Court of Justice on the topic, including 3 Grand Chamber judgments. So the scenario we were confronted with was rather different.
Well, I'm sure it was, but there are a number of factors which are the same, and I'm just addressing the ones which are the same. Para 78, no change in domestic legislation. That's certainly true.
Para 78?
Sorry, Para 78 on page 407.
Thank you.
It would have been open to Parliament to amend section 48 if it didn't like the result. Didn't do that. The bit about international legislative framework, I don't think really applies here. But also I would say that the 4th point, academic criticism, I've already said there's no academic criticism here either. And not even the EU IPO has actually done any criticism as such, of which I'm aware. They've just gone a different way in their own guidelines. Now, I don't think we get very much more because the facts of that case were really quite different. So far as my learned friend's reasons for suggesting that it was right to depart, he gave 8 reasons orally this morning. Now, the first he said was, I may not have got this quite right, but I think I got the gist of it. He said there was a clear inconsistency, and the clear inconsistency he suggested was between the recitals of the directive, High-Tech, Ghibli, Coombe and Budvar. These are the cases he mentioned. Now, my submission, I don't want to repeat myself, but there is no such clear, or indeed any inconsistency. The CJAU is entirely consistent. as one can see from its correction to the General Court judgment in Basile. Ghibli is inconsistent, but it predates Budvar anyway. It's non-binding, even on the EU IPO itself, and I've already explained why I say it's wrong. The General Court judgment in Turk wasn't dealing with acquiescence, say via a side passing reference in one paragraph, which had nothing to do with the result. Now, my Lord Justice Arnold characterised this as a mess. My respectful submission, it's not quite that bad. It may have been presented that way by my learned friend for his purposes to suggest it was rather more confusing than it really is. But in my submission, there is no such clear inconsistency for all these reasons. My learned friend also says that this court is unable to refer questions concerning Section 48 to the Court of Justice. Now, it's true this court no longer has that power, but the House of Lords didn't have that power in 1966 either. And in my submission, losing the ability to ask someone else what the answer to the question is has nothing to do with the Supreme Court test. The correct analysis is simply it's because of the Withdrawal Act, this has been adopted, but we still apply the same approach. And anyway, the Court of Justice already answered the question once in Budvar, and this court referred it. It corrected the General Court's misstatement of that test in Basile, and there's no reason to suppose it would give a different answer if asked the same question again.
But it might do.
All things are possible, but I would suggest there's virtually no grounds for optimism on that front. I don't see why there would be. The General Court's been consistent, as I've said.
Consistent the other way, though.
Well, it's been consistent in Budvar and the correction. I stopped to repeat myself, but
You said the General Court, you meant the Court of Justice.
Oh, sorry, did I? Was that
You
what I
did.
wrong?
You said the General Court.
General Court. I wanted to say the Court of Justice has been consistent. Hopefully, I'm at least consistent with my reference to consistency. Now, my learned friend's second point was that he said Basile showed the unsatisfactory state of the case law. This is really the same point, actually, as the first. But even in Basile, the General Court didn't give any particular reason for wanting to depart from Budvar, even if it thought that's what it was doing. It didn't criticise Budvar, it just inaccurately cited the test. And then it was corrected. Thirdly, he said failing to depart would, quote, unduly restrict proper development of English law. But the only development of English law my learned friend seems to have in mind is the result whereby his clients are allowed to sue mine for infringement of his client's trademarks. What other development is there? What demand is there for a change? How is it going to develop other than for that single consequence? No other consequence was identified.
Well, it's more consequence than that, isn't there? Because if it is the issue of whether there has to be an understanding and knowledge of registration or not, presumably will affect a lot of cases and a lot of the way people approach trademark and acquiescence.
I'm just pausing about a lot of cases.
Well, I don't know. You may or may not realise I'm not a trademark.
No, not at all. It's not criticism.
The Lord, no doubt, would be able to tell me if acquiescence is a common problem or not in the trademark world.
Sorry. Well, Budvar itself was, I think, 2011, 2012. I think it was 2011. It was the Advocate General and the Court of Justice, and it was actually reported in 2012. I'm not aware of any case since then, apart from this one in the UK and Coombe.
Well, there have been other cases in which the issue was raised. So, for example, in the most recent Easy Group appeal, which we gave judgment on a couple of weeks ago, the issue was raised. We didn't get to it because it arose on the respondent's notice, and since the appeal was dismissed, we didn't need to get to it, but it was certainly there.
Yes. I'm not disputing there may be cases where it has arisen. It's just the suggestion there's quite a lot of them. And I think that quite a lot of them only comes in to my learned friend's submission about unduly restricting proper development of English law. Doesn't seem to be an issue that comes up very often. So why would departing make a significant difference?
Well, 3 cases in the Court of Appeal within the space of a calendar year isn't a small number when you consider, what that might be reflective of, firstly, at first instance, and then all the disputes that are settled before a trial, and then all the disputes that are settled in correspondence.
Yes, the cum, for instance, that's all about when acquiescence stops. It's not quite the same point as this one.
To be sure, yes.
I'm not speaking of the cases in which acquiescence raised, but it's a rather narrower question, isn't it?
I think I've raised a red herring. My only point was that to identify it in terms of it's just all about trying to stop your lay client trading, it is not how I perceive this argument.
Yes.
To me, it raises an important issue, potentially important issue, about whether or not someone has to know that the trademark's been registered or not.
Yes, I may well
Issue
fall.
one.
I may well fall into the advocate's trap of. I mean, I think that's why my learned friend's interested, but as my lady says, it might potentially affect other people. All I was really saying, and probably rather ineptly and inelegantly, is that this particular point about Budvar's 4th condition, I think this is the first time that one's come up. So would changing the law on that, or rather a failure to depart, sorry, I'll get it the wrong way around, is departing from Budvar necessary to avoid unduly restricting proper development of English law? Now, of course, every time you're departing from anything, it's going to make a change which affects some people. But there must be something more to that before you can depart applying the House of Lords test. The 4th point my friend made was about striking the balance, including what he again referred to as public protection. And my submission is Budvar does strike a balance, and it's an easy to apply one. The judge applied it here. It's just my learned friend doesn't like where the balance is struck. So there's nothing in that one. His 5th point, I may have got this wrong, but I think he said cum establishes that what the proprietor of the earlier right does is irrelevant whether that proprietor acquiesces in the use. But in my submission, cum establishes no such thing. In cum, they didn't actually know about the prior use, and that was part of the rationale in that case. 6th, my learned friend claimed there was an incentive to avoid consulting the register. Well, is this a problem at all in practice, that people deliberately fail to consult the register? I would suggest in most cases it's unlikely to arise. I accepted earlier that if it's a case of people deliberately turning a blind eye, then the law has means by which it could deal with it. But other than that, why would, quote, this incentive to avoid consulting the register justify departure? The register is a public document. The 7th point was relating to the 6th point, and this was argument about how proof of knowledge of use was easy to prove, and proof of knowledge of the state of the register wasn't. Now, I already made submissions about that, but my learned friend this morning made points about trademark agent privilege under UK Act, and he showed the court various sections. And I said at the time, UK national law can't affect how the directive is interpreted. But that point about trademark agent privilege isn't in my learned friend's grounds of appeal, or either of his skeleton arguments anyway. I should probably show you the grounds of appeal.
Well, why would it have to be? It's just a supporting argument.
Well, I'm just going to suggest it's very much an afterthought. But if it's not in the grounds of appeal, I think my lords could simply dismiss it on those grounds. If I'm wrong about that, my learned friend can show.
No, because what the rule says is that your grounds of appeal must specify the respects in which the judge was wrong, and the practice direction expressly says that the reasons why are not to be put in the grounds, but in the supporting skeleton argument.
Well, I'll just show what the skeleton argument said, then I'll move on to the next point. The skeleton argument, sorry, the grounds of appeal is it's core bundle, page 18.
Just so I'm clear, your submission is that we should ignore.
Yes, hold on to what he actually said. Well, perhaps we don't need to look at it. Well, I've got halfway there. Core bundle, tab 18. Sorry, page 18. And it's subparagraph 2, not doing so would cause injustice, unduly restrict proper development of the law, obiter per incuriam, and the further matters set out below. But the further matters set out below in 3 to 6, before you go on to the next point, are all about alleged inconsistency and inability to refer. Now, the Learnfriend's 8th point, he says, if Budvar had been an English authority, it would not have been, this paragraph 58 would have been no part of the ratio. That's actually wrong, because under the Court of Justice's own rules, it was part of the dispositif, the answer to the question. But we say it's simply a non-question anyway. If Budvar's had been something else, it would have been something else. And nothing more turns on that. So, my submission for all these reasons, the Learnfriend comes nowhere near the high standard required. And this is not an appropriate case for such departure. That brings me to the date point. And the date point, I already showed my lady and my lords the actual register entry for first offence mark in this case. And that dated entry in the register was 25th of May 2016, as opposed to the application date, which was 18th of June 2015. The dates are slightly different for the logo mark, but the point is the same. It has an application date, and then it later has a registration date. Now, Learnfriend went through a number of other materials when he was covering this point. In my submission, these are interesting, but don't really change anything. I'll explain what I mean by that. If my lady and my lords take the sup bundle at tab 9, these are the details held IPO. And these are interesting, but WIPO is neither the EU IPO nor the UK IPO. The EU IPO entry is, again for the word mark 685, is on next tab, pages 51 to 53. Now, the timeline graphic that my Learnfriend spent a bit of time on sets out various internal processing states, but it's merely informative. And I say that because my Learnfriend didn't take my lady and my lords to anything in the regulation saying anything turned on the timeline graphic shown here. And nor is there anything in my Learnfriend's grounds of appeal or either of his skeleton arguments about.
That seems to be a point against you. I thought he was taking us to the timeline graphic in fairness to your argument that the date of acceptance was what mattered, because what it gives us, the registration date in the table underneath, is what he's relying on. He wasn't relying upon the graphic at all.
I'm not sure that's quite right with respect, my lord, because the dispute here is my Learnfriend says that the date when the time starts running is 24th of May 2016, and he only gets that date from the graphic.
No. The date he relies upon is 18th June 2015, which is stated as the registration date.
That's, yes, my lord's right to that extent. But my Learnfriend's actually got two different arguments going. One is the main argument about date of application versus date of registration. Yes. For that argument, it's 18th of June 2015 versus a date in 2016. But he's got another argument going, which is to say that significance should be attached to the date of 24th of May 2016.
In the alternative, yes, correct.
But that date is purely an internal processing date, because...
Well, I don't understand what you mean by that, when this is part of the public register.
Yes, but the answer to that question is the date is 24th of May 2016 for IR accepted.
Yes.
But the date
of publication is the following day.
Following day, yes. And the reason that dispute matters is we actually sent the letter before action on the 24th of May 2021.
No. You issued the claim form.
Sorry, you issued the claim form on 24th of May 2021. But so that's why my Learnfriend wants to try and get back a day. He wants to say that the period of acquiescence...
That's his alternative argument on the claim form date. Exactly so.
Yes.
Is he right about that? Suppose it were the case that the relevant date for the start of the period was 24th June 2015, and you had 5 years. You are right that the issue of the claim form is the end date, and it's issued exactly 5 years later. Is that in time or out of time?
Well, over the short adjournment, my attention was drawn to a case called Matthew and others and Sedman, 2021 UK SC 2019, which says you have a distinction between midnight cases and during the course of the day cases. If it's a during the course of the day the cause of action accrues, you've got until the same day, close of business, midnight the same day, 5 years later, or whatever the limitation period is. If it accrues at midnight, you don't. But if my learned friend's right about the significance he says applies to the date in the graphic, we would have been in time, is the answer. Because he says the IR is accepted on 24th of May 2016, and we issued proceedings on the 24th of May 2021, so we would have been in time. But my submission is the correct day isn't 24th of May 2016 anyway. That's just the internal processing date. The date of publication of the mark is actually 25th of May 2016, and that date appears on page 53. And that's also the date on the UK IPO's register.
Yeah, now that what you just said is very helpful, but can I come back to where this discussion started? Because you seem to be making a submission, and if I misunderstood you, I do apologise, but you seem to be making a submission to the effect that we should simply ignore the date of the 24th of April. Now, if that wasn't your intention, as I say, I apologise, I retract. And of course, you've got the point you've just made, that even if that is the right date, it doesn't matter. And you've also got your submission that the correct date is not the 24th, but the 25th, because that's the date of publication. So you've got those other 2 points.
Yes.
But what I would like to know is, are you saying that we cannot have regard to the date of 24th stated in the timeline? And if that is your submission, why?
Well, the shortest answer actually to that is there's another point. It's not even a grounds of appeal or a skeleton argument. This time I'm entitled to say that. But the second point is that if that were right, then presumably the information on page 53 of the EU IPO register and the content of the UK IPO register on page 59 must be wrong, mustn't it? Because they've got the date of 25th of May 2016.
Well, I don't understand that, because it's perfectly common to have acceptance one date and publication on another date.
Yes.
So you've got some perfectly straightforward points, but I still haven't had an answer to the question I asked, which is it your submission that we can't have regard to the date of 24th May? And if that is your submission, what's the basis for it?
Well, my submission is yes, you can't, but I don't see the grounds in which the court would have.
You're saying we cannot have regard to the 24th of May. Now, that's a clear answer to my question,
Yes.
the first question. So the second question is, why not?
Because it's not the date of registration.
No, that's a different question. That's the answer to the question, what's the right date?
I follow, yes. Cannot
It's
have
not
regard.
an answer to the question, what can we have regard to?
Well, I can't really see a basis on which one can have regard to in such a way that it alters the date of registration. I mean, have regard to, but to what end? We have regard to the date, but it's not the right date.
So, I think where we've got to, and if I'm misstating your position, please correct me. I think what you're saying is, yes, we can have regard to the 24th of May date that is stated, but you say it's utterly irrelevant for the reasons you get.
Yes,
You get.
that's correct. Yeah.
Thank you.
And having regard to it, one could have regard to any of the dates in the timeline, because they're all in a timeline.
Can I just be sure I've understood what is the statutory language we're actually construing? Is it section 48?
Yes, it's always been section 40.
And that refers to what? 5 years from what?
5 years, let's get it. It's the-
Continuous period of 5 years in the use of a registered trademark.
being aware of such use, I think.
Paragraph 30 of the judgment.
So,
Well,
Section 48 itself does not refer to the starting date at all. It just says 5 years in the use of a registered trademark. It's the CJEU which has said that the 5 years only starts on registration. Is that right?
Well, there's a bit more to it than that, but I'm going to go through the UK Act, but since we're on Section 48 at the moment...
I beg your pardon, why is the UK Act of any relevance at all?
Oh,
Because at the material time we were talking about EU registrations, so surely it's the regulation which matters.
Yes, which is Article 6, which is rights acquired by registration. I think I mentioned that one earlier. I was just actually trying to answer the question about the relevance of the right of registration to A is that you can't apply for a declaration, but the registration is invalid until it's actually registered. That was the point I was going to make in answer to my Lord Justice Nugee's question. Is that an answer to the question or not? If not, I'll move on.
Well, that may be an answer, but what's the answer to my Lord's question? Which is that at the relevant time, whether it's 2015 or 2016, when time started running, we weren't concerned with this at all. We were concerned with, well, an article of a directive or
Regulation.
Regulation. Yes. Well, that's actually jumped to my next point, because the point I was about to make was that this deeming provision going back to the date of application only applies to the UK mark anyway, and therefore we should be looking at the registration. When I refer to the deeming back provision, does my Lord understand what I mean? That's learn French.
Article 1892 says that under the Madrid Protocol, once it's registered, it dates back to the date which it appears in the WIPO. Doesn't it?
Yes. Well, let's do the CTMR, and then I'll explain why the UK isn't any different. So far as the registration procedure generally is concerned, EU IPO, it's similar in the sense that you have an application, and then you have an examination, and then you have publication of the application, if the conditions are fulfilled, and then potentially an opposition, and then if there is no opposition or it's been rejected, the mark is then registered. So the point is it starts with an application and finishes with a registration. Now I'll show the court Article 6, which is A2.1, which I already mentioned.
Now, it's not your fault, because Mr. St Bill, for understandable reasons, went to the 2017 regulation, but that's not, in fact, the correct one. The correct one, ratione temporis, as the Court of Justice likes to say, is the 2009 regulation.
It is. So we need page 192 for that. Page bundle A2.1, tab 27. Page 192. And that says quite simply, an EU trademark shall be obtained by registration. Now, the importance of that I'll come back to in a minute, but it also follows that until you get registration, there is no such thing as an EU trademark. There's merely an application, which may or may not be granted. This one refers to an EU trademark, because the name changed. It's the same thing as a CTM. Now, there were various, what I'm going to call backdating provisions, even at this time, and in this version, they were in Article 9b. Which is page 197. And this says, this refers to the date from which rights against third parties prevail. And number one, the rights conferred by an EU trademark shall prevail against third parties from the date of publication of the registration of the trademark, not from the application. And it also says from the publication of the registration. So that's the actual date when they have effect. There is a limited exception to that in subsection 2, which is reasonable compensation may be claimed in respect of acts occurring after the date of publication of an EU trademark application, where those acts would, after publication of the registration of the trademark, be prohibited by virtue of that publication. Now, the point about this section is it's talking about the heading, it says third parties. Now, that wording is apt to cover infringers, certainly, but I would submit it's apt to cover earlier proprietors as well for purpose of statutory acquiescence.
What do you say about paragraph 3?
I would say it's not particularly relevant, really, to the purpose of what the date
It
is.
envisages that you can have proceedings on the merits prior to publication.
Yes, that's true, but it shall not decide upon the merits. I don't know if this envisages some form of interim relief or interim preservation of property or something.
Well, what it appears to suggest is that you can commence your proceedings, never mind about interim relief. It appears to suggest, does it not, that you can commence your proceedings even though the registration has not been published. What you can't get is a decision of the court on the merits.
Yes, yes, that's certainly true. But you wouldn't be able to get anything that involved merit, such as a final injunction, for instance, or a claim for damages, until the registration has been published, because then you're back in Article 9b(1) territory.
Yeah.
So the action.
But once it's been published under 9b(2), you would get compensation not only from the date of publication of registration, but right back to the date of publication of the application.
Yes, but not back to the application date itself.
I see.
And that's only aimed at, as it says, claiming reasonable compensation in respect of acts occurring. There's no general backdating, by which I mean that for purpose of statutory acquiescence, for instance, you go back to the date of application. That was what the courts considered in the cases I drew the court's attention to this morning. So that was the EU approach. I should probably show that the UK approach was different. Now, I want to say the UK approach was different in the sense that it leads to a different result if my learned friend is right about dates being the date of application. It doesn't lead to a different result if my submission is correct, that it's always the date of registration. Because the date of registration of an EU mark, then all the rights kick in. And similarly, for purpose of acquiescence in relation to a UK mark, I say the correct date is the date of registration.
Yes, well, I'm sure you're right to have a look at the UK provisions in a second, but before we do that, as I see it at the moment, the sheet anchor of Mr. St Ville's case is whatever article corresponds to 189 in the 2017 version of the regulation. So I think we need to get your submission on what that means, but let's find the right provision first. In this version of the directive, regulation, I'm sorry.
And then the phrase says it's 151. Yes, well, this is just saying it's Article 151 is on page 277.
Thank you.
But all this is saying is that an international registration designating the union, etc., of which this particular mark was, shall from the date of its registration pursuant to Art 3.4 of Madrid, or from the date of subsequent designation union pursuant to Art 3.10.2 of the Madrid Protocol, have the same effect as an application for an M1, for an EU trademark.
Yes, but he's relying primarily on paragraph 2, so what do you say about that?
Oh, this goes to the internal refusal of protection point. Well, if my learned friend was right, international registrations designating the union would be somehow entitled to greater protection than applications made at EU IPO itself.
Or why not? Because they have the benefit of an international registration.
Well, because it says, Article 151.1, it should have the same effect as an application for an EU trademark.
Yes, that's a good answer as far as paragraph 1 is concerned. What about paragraph 2?
Well, maybe at cross purposes, but if the Lord is saying that the international market is somehow superior to any other...
I'm not saying anything.
Yes.
All I'm saying is that I understand Mr. St Ville particularly to rely upon paragraph 2, and I'm keen to hear what your answer is to him.
Well, my answer is simply, if you go to Article 4 of Madrid, the protection obtained by the international system is the same as if the application had been made directly.
Well, but by all means, let's look at Article 4 of Madrid at the moment. But what's the answer on 151 paragraph 2?
Oh, it's not that shall from the date referred to in paragraph 1. Is that the particular words?
So the date referred to in paragraph 1, we know, is the date of registration pursuant to Article 3.4 of Madrid Protocol. We know what that is on the facts of this case. But what Mr. St Ville particularly relies upon is the words shall from that date have the same effect as the registration of a mark as an EU mark. And that's in contradistinction to the wording in paragraph 1 referring to an application for an EU trademark.
Yes, I see what my Lord says now. Well, my only answer to that isn't one based on Article 1512 at all. It's a submission I made earlier about it can't have more rights than a mark, an application which is made directly. Now, I know this isn't a direct answer to 1512, but it is a direct answer to what's required by Article 4 of Madrid. And that is at A2 122, page 41. And this deals with the effects of international registration. So 41A, from the date of the registration or recordal effect in accordance with provisions of Article 303 ter, the protection of the mark in each contracting parties concerned shall be the same as if the mark had been deposited direct with the office of that contracting party. And then you get the bit about if no refusal has been notified, or a refusal notified in accordance with said act being withdrawn subsequently. The protection of the mark in the contracting party concerned shall, as from the said date, be the same as if the mark had been registered by the office of that contracting party. But I don't agree with my learned friend as to what this means. What I say this means, because it is the effects of international registration, is that the effect of international registration is the same as if the mark had been registered by the office of the contracting party in the first place. You don't get a queue jump advantage.
Sorry, what is the said date in the penultimate line of Article 41A?
That would be the date of the registration or recordal effected in accordance with provisions of Article 3 and 3 ter.
And what is that date in this case?
I'm not sure what that date actually was.
It's the 18th of June 2015.
It's the 2015 date, isn't it? Doesn't it mean registration as an international mark at WIPO?
I see where my Lord's going, but if that's right...
Well, what is your submission? That's what I understood Mr. St Ville to say. What is your submission? Is he wrong about that?
Well, my submission is simple. It can't be right, because if that's right, the UK IPO register is wrong.
What is the said date in your submission on the facts of this case?
The said date must be the date appearing in the UK register, which is the date when the thing is published.
Well, there's two different things here, and apologise for piling in with questions, but you've made a submission about the wording of the Madrid Protocol, which I understand, but en passant, you said that if the contrary view was taken, the date on the EU register would be wrong, but that's not right, because the date, as we saw earlier, the registration date given in the EU register is indeed the 18th of June 2015, which is the same as the international registration date. So, in fact, the EU register would be right, not wrong. Now, that's got nothing to do with the question of what the legislation means and what its proper interpretation is. But it's factually incorrect to say that the EU registration date is anything other than the 18th of June. I mean, it's a question of what they mean by that, of course.
Yes.
But what they give as, quote, the registration date is 18th June 2015, which is the same as the wipe-up date.
Yes, on the grounds that that's absolutely right, but it's not the date on which the registration was published.
No,
Because we've got that from Article 9.
quite so.
Well, I suspect I can't offer any more answers other than I already have done. So I'm going to have to move on.
Can I see if I can summarise your submission and see if I got it correctly? What you say is that the whole basis of the Madrid system is that it's a convenient mechanism for getting national or regional registrations. It's not intended to give you superior rights. If you look at the EU system, your rights, essentially subject to the limited point under 9b2, date from registration, not application. And you say it can't have been the intention of the drafters of the Madrid Protocol to change that merely because you apply via the international route than directly via the EU route. Have I got your submission correct?
Absolutely, my lord. That's it, exactly. So I think I should probably just deal with the UK position, but I'll try and do so briefly, because my own friend did go to that. In the UK, there's a backdating provision that the rights of registration go back to the effect of application. But that's a homegrown UK provision. That wasn't in the directive. And as I said earlier, I don't want to repeat myself, but if the relevant date is the date of registration, then in my submission, the CTMR and the UK Act are consistent. If there's a backdating provision in the way the UK has applied Article 9 of the Trademarks Directive, then there is some inconsistency there. But the short answer to the backdating point under UK law, apart from the fact it's purely a matter of UK law, is that only affects your rights against third parties. And the judge made that point in the decision under appeal. It's got nothing to do with statutory acquiescence. I could show my lord's section 9.3 of the UK Act, which talks about the reference to the rights of the proprietor. But I'm just not going to do that, actually. I'm going to say, to conclude on this point, if my friend is right, there is this profound difference between the way the UK marks are to be treated for purpose of acquiescence because of the UK backdating provisions, and the way EU TMs are to be treated because they have no such provisions. Then the marks and issue in this case went through that profound difference at midnight on 31st December 2020 when they converted from being an international registration EU.
Yeah, and that would be contrary to the whole objective, which was to ensure you got the same rights.
Yeah. Okay. So that is all I'm supposed to say about the time running point. Can I come to the respondent's notice point? And the first is the end of acquiescence point. Now, I already took my lady and my lords to High-Tech and to Coombe for a different purpose. Can I summarise what I say the position is? The position of authorities is this, that I accept that merely sending a warning letter without more is not enough to end a period of acquiescence, and that actually issuing proceedings for a declaration of validity plainly is enough. My submission is these are the two extremes, and it doesn't follow that everything falling between these extremes also fails to end a period of acquiescence. And on the contrary, it's a matter of fact and degree, depending on whether the earlier proprietor pursues its efforts beyond a warning letter within, quotes, a reasonable period, close quotes. And the judge in this case didn't have to consider that question, so it falls to this court to do so. Now, the passages of High-Tech we need to look at are different, but they're quite short. If I could invite the court to take A1.1, tab 7, page 245. And it's all about what stops the period of acquiescence running. Page 245, I'll direct the last to paragraph 52. But the key paragraphs are really 54 to 56. Because in 54, whereas in the present case, the bringing of that action, and that was an action which interrupted the period of limitation, was preceded by the sending of a warning letter, which they didn't comply. The warning letter may interrupt the period of limitation in consequence of acquiescence, provided that following an unsatisfactory response to that, proprietor of the earlier mark or earlier right continues to express its opposition to the use of the later mark and so on. And in contrast, paragraph 55, this is where I get the words about pursuing its efforts within a reasonable period, and why I emphasise the words about within a reasonable period. So in other words, if you had the warning letter but you don't pursue your efforts within a reasonable period, it's unfair proprietor failed to take measures to put an end to the alleged infringement. And the particular vice they're worried about is repeatedly sending a warning letter approximately every 5 years. That's paragraph 56. So it's certainly not enough just to send a warning letter every 5 years. That was high-tech.
Well, we've got to go on to 57.
Yes.
Because what they say there is that sending a warning letter is insufficient without taking the necessary steps to obtain a legally binding solution.
Yes.
So the argument against you is that what you've got to do is to take, quote, the necessary steps to obtain a legally binding solution.
Yes, absolutely. And of course we did do that in the end. And then the question is, did we do it quickly enough? That's essentially the point.
Quite so.
So it's not a case where I never did anything at all.
Yeah.
Now, so far as Kuhn, I don't think I really need to go to that. My Lord Justice Arnold referred to my Lord's own previous decision, W3 and Easy Group. But the point in Kuhn was there was no letter before action at all. So it's interesting, but it doesn't really take us anywhere. So what were the facts here? Well, my Lords have heard about the facts, but there's two key facts, which I don't think my Lords have heard very much about, which I will mention. And one is what the judge called negotiating tactic, and the other is the effects of COVID in 2020, which practically killed off all the acts complained of. Now, my own friend did take the court through the various letters, and I don't propose to do that again. I'll just try and make some submissions about them. But so far as the judge's findings are concerned, again, I know my lady and my lords have read the judgment, but one of the findings made in paragraph 67, sorry, it's paragraph 67, my skill is 67. Well, the finding was that the defendant's UK sales over the period 2013 to 2019, and so was the amount of the defendant's ICE branding. And as I said earlier, it was the launch at the cleaning show on the 1st of March 2019 which generated all for customer confusion and led to the first letter before action. Now, the letters before action, the court's been shown them. The first letter, which is at sub 16, that was directed to the UK company, in fact D3, which is the head of D4. And that's the letter which complains of all the activities in the UK which were done and demands the undertakings. Don't need to say anything more about that. The answer on the next tab was given on behalf of a number of people, one of which was the Hong Kong company, and the other is ICE Holdings, which is the BVI company, as well as the UK distributor. And this is important for two things. Firstly, they draw my client's attention to their marks, and that's the source of the judge's finding. It was in this letter of this date that we found out about their marks. But the undertakings, the request for undertakings is refused. We see that from the last sentence. So then there was the, well, there's quite a lot of other correspondence, but there was this breakfast meeting at the Las Vegas Cleaning Show on 20th November 2019, which formed the major dispute at trial. And for this purpose, I do want the judgment. And the judgment is, covers this, paragraphs 109 to 112. and it's approaching the end of the judge's narrative about what actually happened at the Las Vegas meeting. And in paragraph 109, there's a reference to a letter which was written by Mr. Marston of the Claimant to Mr. Chen of the ICE group on the 19th December. And sorry, it was actually an email, I think, rather than a letter, in which the Claimant set out what it said was agreed at the meeting. And 2 lines up from the bottom, the judge says, Mr. Schless says that suggested to him that C was not serious with regard to its objection to the use of the IC brand in the UK, but accepted in cross-examination that he thought at the time that C would continue to pursue its challenge to D1's 2015 trademarks. So the defendants are under no illusion, as of December 2019, that the Claimant continued to object to the defendant's activities. And then we come to the judge's findings, beginning at para...
Is that the finding? C would continue to pursue its challenge to D1's 2015 trademark. So that's the challenge to the validity of the trademarks, not challenging use in the market.
Oh yes, that's right, yes. But, yes, but that was Mr. Schless's acceptance that he thought would carry on pursuing its challenge to the trademarks. Yeah. Except it's not about use. But he knew we weren't happy about what they were doing, and particularly with respect to D1's 2015 trademarks. So that's the background leading up to the meeting, and then the judge makes the findings. And at the bottom of para 111, the judge accepts the Claimant's evidence that Mr. Bresner and Mr. Martin believed an agreement had been reached with Mr. Chen. So that was the Claimant's belief, but the judge finds no concluded agreement was actually reached. And the reason why, or rather to put it into further context, the judge says at para 1112 that 3, the statements and indications made by Mr. Sless and Mr. Chen were no more than a negotiating tactic. So that's the negotiating tactic. Somewhat charitable way of putting it. But in all those circumstances, I submit it was reasonable. One can see what is reasonable for Claimant not to embark on expensive litigation at that stage, because it believed the problem had gone away, even though it was just a negotiating tactic unknown to the Claimant. And then the second key fact is COVID, and the effect of that is set out in Judgment 193. And the judge refers at the end of this paragraph, Mr. Kelly's witness statement shows that Killis bought about £354,000.
I beg your pardon, can you give me the reference again?
Yes, para 193, page 71.
Thank you.
Last sentence, last 2 sentences. Mr. Kelly's witness statement shows that Killis bought about £354,000 of ICE Group's products in 2019 and about £3,516 in 2020, which the judge describes as an almost total cessation of that business. It's not until 2021 that it began purchasing again and fully branded ICE Group products returned to the UK. So, in my submission for this further reason, it was throughout 2020 reasonable to suppose the problem had gone away, but for a different reason. They're just not selling anything. There's almost total cessation of the business. And it's against that background, the judge's findings, that one comes to a second letter before action, which is subbundle tab 21. That was the second one. My learned friend took the court to it. He's right, this wasn't pleaded, but it was, and we've given the reference in our skeleton, it was in undisputed evidence. It was mentioned in closing submissions. My learned friend answered to these closing submissions. He didn't take the not pleaded point, he just said it's not a proper letter before action. But it's true that it doesn't ask for fresh undertakings, but there's no point in doing that because that had all been rejected already. It does say the use will not be tolerated. Your clients continue passing off infringing and or other unauthorised use in respect of sales of product UK under the name IC will not be tolerated. And then in the next page it goes on to say, while I considers next steps, please inform us whether you also represent Killis and or any other distributor in the UK, whether you're instructed to accept service on behalf of your clients and whether you agree to accept such service. So by the time they're talking about are you instructed to accept service by email, that would have made it clear to the recipient that pleadings were imminent. So there's been no change to our case on appeal. This is all material which was before the judge. And if I pull this together, my submission is it's not simply a case of sending a warning letter and then doing nothing. It was sending not one but two letters, followed within a reasonable period by action for infringement and invalidity of their marks to restrain the use complained of. And my submission, it was reasonable, having regard to the dealings between the parties, including the claimant's belief that the problem had gone away as a result of the negotiating tactic, what the judge found with a sharply reduced sales. So it was reasonable in the circumstances, and I would submit that even if a learned friend overturns the judge's finding as to when the period of acquiescence started, it still ended before any 5-year period had elapsed. And I've given the court the dates, the first leg before action, the second, and then the long stop is the actual issue proceedings. So then the second respondent's notice point is, does statutory acquiescence bar an action in passing off? Now, one of my learned friend's points was procedural. My lady indicated that these weren't going to be decided. But my first point to make is that whatever the correct...
Sorry, no. That wasn't what my lady said.
Well, it wasn't going to be decided at
What
that
she
stage.
said was we weren't going to give you a decision here and now, as opposed to in the judgment.
Yes, I'm sorry, I meant not decided now, rather than not decided at all. Of course it's going to be decided. Well, I was just simply going to say, whatever the correct characterisation is, my substance of my client's position is the same, because we say it's the same acts which the judge found amounted to trademark infringement, also amounted to passing off. And one gets that from para 9 of the judgment, which sets out the acts alleged to amount to infringement, and then para 10 explains that these acts that the defendants complained of constitute passing off. It's just that the judge didn't consider it necessary to deal with passing off. So it's the same acts. And there was no adverse finding about passing off, because there's no adverse finding in the order the judge made. And my learned friend's appeal notice, section 9, he asks for an order dismissing my claim and passing off. So it can't have been dismissed already. Otherwise, he wouldn't be asking for that. But the key point is the substantive one, about whether Section 48 affects the law of passing off, or whether I can rely on Section 2.2 at all. That's the key one. Now, I'm sure my lady and my lords will be familiar with the general principles of statutory construction, one of which is that more specific provisions override the more general. But of course, Section 2.2 is the more specific because it refers to passing off. And Section 48 is the more general, which refers to earlier rights. My learned friend took the court to the earlier rights might be several things. It might be passing off, that's true, but it might be copyright, it might be things like a right to a name or some other industrial property. Now, we did put PACAR into the authorities, but I sense I'm probably at borrowed time as well. Can I just submit the assumption, submit the approach that I invite my lady and my lords to adopt? It's an entirely standard approach of considering the mischief which the Act was intended to remedy and the presumption against absurdity. And absurdity is interpreted quite broadly, as pointed out in PACAR paragraph 43, that's A345, page 241.
Can I ask you a question about this? Because it goes back to what we were talking about earlier. Certainly at the time when time starts to run, the applicable legal provision, as we were discussing earlier, is 2009 regulation, which has direct effect in the UK. Now, subsequently, it gets replaced by the 2017 regulation, but it doesn't matter because there's no material difference in the relevant provisions. We then get to the 31st of December 2020. Time is running.
Yes.
Brexit takes effect on that date, and overnight, literally, the EU registrations are replaced by comparable UK registration.
Yes.
So what then is the applicable legal regime as at the date when one is considering whether time has been interrupted or not?
Yes, I say it's the first. I say it hasn't changed because it'd be quite odd if it changed as a result of Brexit.
So you would submit that the applicable legal regime is the regulation,
Yes.
not the Act?
Because it's an international mark, EU. Yes, that's right.
And if that's so, what is the relevance of Section 2.2?
The relevance of Section 2.2 is that there never was well, the point about that was, I thought my first answer is my learned friend hasn't got that as grounds of appeal either. My Lord's, I'll answer the point, but it's not actually.
But it's your respondent's notice. He doesn't need a ground of appeal for this.
Yes, the paradoxical thing is he actually says it's the other way around. He actually says that it should be governed according to the UK. I think the logic of my position is that if it continues to be governed by EU rule, then I've got my Article 6 point and say it's all the date of registration anyway and rely on that.
Yes.
But all I could really say about Section 2.2 is, well, just taken by surprise by the point. I couldn't put any more than that.
Sorry, I'm not sure I've understood that. What do you mean by that?
Well, it wasn't one of my learned friend's arguments, is all I can say.
Yes, but look, let's back up, and I apologise if I've set
I don't
hair
think,
running, but where we're at now is you have a pleaded claim for passing off, which is a matter of English domestic law, is perfectly straightforward. You also have a position where, for understandable reasons, the judge hasn't decided that one way or t'other. You say, on the basis of the findings of fact made by the judge, it's a good claim. To which the answer comes back, but it's barred by acquiescence. So we then have to say, well, is it barred by acquiescence or not? And that depends on the legal regime. And you were disposed to accept, to answer my question, that the applicable legal regime was under the regulation, not the 1994 Act. And where that then takes us to, well, is if that's correct, of what assistance to you is Section 2, subsection 2 of the 1994 Act?
yeah. My Lord's put it very clearly, and the answer is I have no answer to that, other than the point about taken by surprise and so forth, not in the written arguments for this. But there's two other possibilities. One is that my learned friend is right, and there is a change at the end of Brexit, which means that the international mark EU is now treated as a comparable mark. And the effect of that is it's treated as if it's always been a mark under the UK Act.
Well, indeed. I mean, that's a possible analysis, indeed.
Yes. And on that
But what do you say is the right analysis?
Well, I think I've stopped. I'm not going to go back on what I've just said. I've answered my Lord's question. I've said what the right analysis is, and I've accepted that on what I say is the right analysis.
Well,
the point doesn't apply.
You don't feel inhibited just because you've said one thing. On further reflection, it's open to you to submit the opposite. These are not straightforward questions. I've asked a tricky question here, and if with the benefit of the discussion you think the right answer is in fact the second answer, then by all means say so.
Yes. Well, that's certainly. But for me, I find it difficult to see why the treatment of the mark would actually change as a result of Brexit. The acquiescence period set out in the UK Act. I just find it difficult to see. Once you've decided what the correct approach is, why would it change as a result of Brexit? But I can legitimately say on my learned friend's argument, it does have exactly that effect, because he accepted it started off as an international mark, EU, so it's subject to the community rules. But then now it's a comparable mark, and he went through all the Brexit provisions, it's treated as if it was under this Act. And he relies on that for the purpose of his second round of appeal, because that's how he wants to get the backdating provision, which you can only get under the UK Act, and you can't get
I think
under...
that's fair comment as far as the written argument is concerned, but starting with the supplementary skeleton and then made even clearer in oral submissions, it turned out that what he was really relying upon was the Madrid Protocol, which was always relied on, in combination with what's in the regulation.
Yes. But his end result has to be, I mean, it is a UK mark now, it's a comparable mark. Therefore, it is a mark existing under the UK statute. It doesn't exist under any other statute.
For sure, that's the current position, yes.
Yes. So,
But that doesn't necessarily determine the question of what's the applicable legal regime for determining when acquiescence comes to an end.
that's true, but if I was right, if I'm right that passing off is purely domestic, it wasn't affected by the laws of imposed by Section 48, my learned friend is now back in that position. So the fact that he might have had a defence for some period of time doesn't actually help him. All it means is I couldn't get damages or profits for that period during which he had the defence. Is the Lord with me on that? If it's now a UK mark, and if I'm right that Section 48 doesn't provide a defence to the UK mark, and the changeover was 1st of January 2021. Now, it depends which date one has for the start of the period. But if the long way round is that it's now a UK mark, and I'm right that Section 48 doesn't provide a defence to passing off, the most he could ever say was that he might have had a defence for some point of time.
I understand the logic of that, but then that takes you back to the starting point, because that's an argument whose premise is the applicable legal regime is Section 48.
Yes.
But then one has to ask oneself, well, why is that the applicable regime? Given that it's the inception of the limitation period, the regime was undoubtedly the regulation. So you have to postulate that come midnight on the 31st of December 2020, suddenly the applicable legal regime for determining when acquiescence, which is running, ends, suddenly overnight it changes. And changes not merely in terms of it being a UK versus EU provision of corresponding effect, but materially different on your argument.
I follow that. But actually the consequence of that is if you want to avoid the change, you've got to take what it is now, which is a UK mark, a comparable mark UK.
So that would lead to the suggestion that we should apply the UK law throughout.
Yes,
which is, as you've just pointed out, Mr. St. Bill's original stance.
Yes, exactly, it is his position, and that's why, on that basis, well, to avoid the change, the difficulty I've found with this is, and I think I said about my skeleton argument, why is my learned friend that the Brexit Act changed any of this? Clearly wasn't intended to have this particular effect. You could only have it by some side effect and some larger point. It also only works if there's some difference between EU trademarks and UK national marks.
Well, the key difference is the one we've already identified, namely that if we're in the 1994 Act, you rely on Section 2, subsection 2.
Yes.
If we're in the regulation, you can't because there's nothing corresponding.
Yes, exactly. Yeah. Yes. Well, I probably can't take it much further than that, but to avoid a change, if one avoids a change, there's only two ways of doing that. Either it's still to be treated as an EU trademark, which plainly must be wrong in my submission. The UK can't continue to treat it as an EU trademark because that's all gone. Or you treat it as a UK trademark all along, in which case my argument does come in.
All right, well, let's assume for the going forward, the applicable legal regime is the 1994 Act. So therefore, Section 2.2 is available to you. And you've made the general submission, well, that's a specific provision, Section 48 is general. Why so, and why does that lead to Section 2.2 trumping Section 48?
Oh, well, Section 2.2 is much clearer than I think I said this already, but I can. The point about the earlier right, it was actually rather wider. It was a wider definition than just the law of passing off. If we look at section 5 of the Act, and that's A2. It's going to be easier to go to the unofficial consolidation of this, which is actually in.
I think you deal with this also in your skeleton argument towards the end.
Yes, I did.
Just rereading your paragraphs 86 onwards.
Yes. Well, that's certainly the argument I'm about to do. I was actually just going to show the court what the section actually refers to. Yes, can I just make good the point I was making? If I could invite the court to go to A22 tab 32, which is the unofficial consolidation of the Act. And the point about this was, yes, beginning of section 5 is page 455. And section 5.2 is all about you shan't register a mark if it's identical to an earlier trademark and is registered with goods or services similar to those which the earlier trademark is protected. That's talking about the registered position. But section 5.4 says a trademark shall not be registered if to the extent its use in the United Kingdom is liable to be prevented. And then it refers to three things which are defined as an earlier right. And one sees that from the closing words of section 4. A person thus entitled to prevent the use of the trademark referred to in this act proprietary of an earlier right in relation to the trademark. So earlier right is actually a broader phrase because 4A, it probably is even wider than passing off because any rule of law, in particular the law of passing off, protecting unregistered trademark. AA is any enactment or rule of law providing for protection of designations of origin or geographical origins where the condition in subsection 4B is met, or B, other earlier rights such as the law of copyright or law relating to industrial property rights. So you could interpret section 48 when it's talking about earlier rights. Well, they can't have meant passing off because of section 2.2, but they could have referred to the other earlier rights, which is referred to here in AA and B. Now that's the key point on the wider definition of earlier right. And since we've got section 2.2...
What do you say about the fact that section 2.2 originates from the 1938 Act and probably, for all I know, goes all the way back to 1875, and is therefore of long-standing domestic origin, whereas one of the key purposes of the 1994 Act was to implement the first trademark directive, including specifically section 48.
I think that probably helps me, doesn't it? Because it doesn't become devalued because Parliament had referred to it previously. It reflects a long-standing policy. That was exactly what they wanted to do. And the purpose of the 94 Act was much narrower. If the court still has A22 open, and go to tab, yes, here we are, page 452. This actually says what the purpose of the 1994 Act was. It wasn't to change anything to do with passing off at all. It was to give effect to all the objectives set out there. So the mischief, if one likes, that it was addressing was, well, it was all about making all this new provision in accordance with all these council directives and regulations and so forth. And yes, it's giving effect to the Madrid Protocol, even certain provisions of the Paris Convention. But it wasn't intended to change the law in passing off in any way, shape or form anyway. So why would it be thought to have that effect? And on the same page, we actually have section 2.2. Well, friends, right that it says no proceedings lie to prevent or recover damages for the infringement of an unregistered trademark as such, but nothing in this act affects the law to passing off. And he says the word but is really important and suggests it's in some way limited. No, it's not limited. It says in terms, nothing in this act affects the law of relating to passing off. But if section 48 is interpreted the way my learned friend says, it has made a change to the law in passing off. And that's the essential point. Now, and so that's why I say that section 48 should be read in the way that earlier right is rather narrower, but in a perfectly legitimate way. It's just read in such a way that it doesn't, it can't give a new defence to passing off where none existed. But the other point is that if I'm right on that, I do win on passing off, is what I say. And that's on the basis of all the judge's findings, because the judge made a number of findings. I've got an eye on the time, I won't go through them all. But the judge considered whether the use of their 2015 mark should be prevented under the law of passing off. And the answer was yes. And that's the one which is registered for floor cleaning machines. And then the judge went through the same exercise for the 2020 marks. As my learned friend said, they're not particularly relevant. It's the same law plus the words cobotics and robotics in much smaller type. As the judge said.
Can I ask you this question? I mean, obviously you set out in your skeleton argument quite fully why you say on the basis of the judge's findings of fact you win on passing off. And I quite understand the submission. But if it was that straightforward, why didn't the judge say so?
Yeah, well, the actual
she gets to the end of the judgment. She feels it's unnecessary to decide passing off, and so she doesn't. She leaves it open. But doesn't that suggest that she didn't think that the issue followed as night followed day from her earlier findings?
Well, I can't speak for the judge, but the judge simply says the judgment is too long.
Yes.
And she'd considered it all. With respect to the judge, it's not quite clear how much longer it would have had to be, because the 2015 marks are the nub of it anyway.
But this is my point, because see, why did she not say, having regard to my earlier findings, the claim for passing off succeeds? On your case, that's all she needed to say.
Yes, because there's no suggestion of any difference, any material difference between the goods which were covered by the registrations and the goods that they're actually using.
But it suggests the judge didn't see it that way. I mean, that's the question I'm asking.
Yes, well, I can't take any more than the judge's own answer, certainly.
Yeah.
But my submission is it would have been just an extra paragraph, because it's really quite difficult to see. Because one can see that from looking at my learned friend's skeleton. He says, oh, there's no confusion, it was all local trade, or it was all these things. These are all the arguments that he ran against the judge's reasoning on the 2015 marks being prevented under law of passing off, and also the 2020. So there's no new arguments there.
So the alternative course, of course, would be to remit the matter to the judge.
Absolutely. We do accept that's open to the court. We do say that in our respondent's notice. We also say it's very much to be avoided if at all possible, because of all the money that's been spent getting thus far. Plus, would it not be disproportionate, particularly for a case in IPE, Intellectual Property Enterprise Court? What's actually going to happen? One would like to think it's going to be fairly straightforward, but the reality of the thing is, once we go back, then that's an expensive and time-consuming exercise. And what possible reason is there to think that the result would be any different? My learned friend has just given all the same arguments he lost on. He hasn't given any fresh argument as to why he says he should win on that. And one of the first things I said was I drew this court's attention to all the evidence from the defendant's own witness about the extent of confusion, so much so that they told the foreign manufacturers to stop using the marks to quite an extent. And that would be powerful evidence in any trial of passing off. But what would the answer to that be? It's all in the past. We can't have any fresh evidence about that.
Well, if the matter is remitted, it wouldn't necessarily open the matter up for fresh evidence. It can be remitted for a decision based on the existing evidence and the existing facts found.
That's true too, yes.
And that would also limit the costs.
Yes, it would limit the costs quite considerably, but is there any advantage to that even?
Yeah, so your submission is in that scenario, we're as well placed as the judge.
Yes, because it wouldn't depend on assessment of witnesses. In fact, one has the judge's assessment of the witnesses, which is generally positive as far as claimant's concerned. I've been keeping a look at the hour. I know I'm 20 minutes over my hour. Could we just take a moment to see if there's anything else?
Of course.
Thank you very much. These are my submissions.
Thank you very much. Now, we've got some reply and then issues 4 and 5.
Reply issues 4 and 5. Some of them.
And you've got, between you've got an hour and, well, no, it's an hour and 3 minutes according to my watch.
So, my lady, so far as points of reply concerned, my learned friend took you to bundle 2, tab 12, and suggested that there was great significance to the date of entry in the register. But as my Lord Justice Arnold pointed out, that just simply does not reflect what's come from the EUTM file, and what which, if you turn back to tab 10, says the registration date was 18th of June 2015. So that all that can be about is a transcription of data. You've got to look at the legislation to look at the legal effect. And we'll come back to that. Then my learned friend made a point about the scope of the counterclaim. And I just need to show you my pleading to make good point that my Lord just...
Well, we looked at the pleading and we have the point that my Lord...
There was the point that my Lord made. There's an additional point in the pleading that makes a difference. It's bundle 1, tab 13. Paragraph 28.1. So that's the explanation of the activities from 2015 to at least February 2016. The distribution, sales and rental services, and the last sentence says, no complaint is made about such activity by the claimant. So it just makes that point absolutely clear, drawing an absolutely clear distinction between those services and then the goods. And the effect of the prayer for relief would be dealt with on the order by the court. And my Lord Justice Arnold's right that it's not a claim to stop them dealing with services. Then the debate that my learned friend entered into about passing off at the same time as a debate about the Madrid Protocol, the regulation and the UK Act. First point to make is that the pleading in the action relied upon both Section 48 of the Act and Article 61 of the regulation, so both regimes. And the point was made clearly in the skeleton argument, as you identified. The way to look at it in my submission is that Article 4 of the Madrid Protocol is absolutely clear. Article 4.1, from the date of the registration in accordance with the provisions of Article 3, then the protection of the mark in the contracting party concerned shall, as from said date, be the date as if the mark had been registered by the office. And that makes sense when you have a basic registration on which it's based. It's an international promulgation of a registration regime that can be undone by refusal, but the international agreement that's the basis of this is for registration as of the date of the international registration. And that's why the international registration is the key, and the EUTM register accurately reflects that registration date. Then the court made the point about the law at the relevant date. And my submission, the relevant date is the date on which the acquiescence period expires. And my submission is that's the 18th of June 2020. And Regulation 2017-1001 came into force on the 6th of July 2017, and it provides Article 212, it shall apply from the 1st of October 2017. And I particularly point out that date because otherwise our chronology is unfortunately apt to mislead, because it doesn't quote that date, it quotes a slightly early date. But the point is, therefore, so far as when the acquiescence period expired, the relevant provisions are of the 2017 regulation.
But the oddity of that is it kind of presupposes that you're right that the relevant date to be asking the question is June 2020. Well, because if the relevant date to be asking the question is 2021, then the legal regime arguably has changed.
Well, in my submission, the legal regime hasn't changed. I'll come on to that very quickly. But if you're either of the parties or a court on the 19th of June 2020, the day after the period's expired, and you ask the question, has the period expired? You do that by reference to this regulation.
Well, that's uncontested insofar as it goes, because there is no other applicable legal regime.
At that point.
At that point.
So there could be an accrued right. So it's relevant to look at that because you then go through the transition. And the provisions, I know I took them to you before at the beginning, but it really does pay turning to them then. Article 61 on page 326 says in Article 61, limitation in consequence of acquiescence, sub-article 2, missing out the irrelevant words, where the proprietor of another earlier sign referred to in Article 8.4 has acquiesced for a period of 5 successive years in the use of a later EU trademark in the member state in which the earlier sign is protected, while being aware of such use, he shall no longer be entitled on the basis of the other earlier sign to apply for a declaration that the trademark is invalid in respect of the goods and services for which the later trademark has been used, unless, of course, bad faith. And then, Article 137, prohibition of the use of EU marks. Second sentence of Article 1 says claims for infringement of earlier rights within the meaning of Article 8.2 and 4 may, however, no longer be invoked if the proprietor of the earlier right may no longer apply for a declaration that the EU trademark is invalid in accordance with Article 61.2. So that's the primary provision to construe, because that sets up the legal position from if I'm right, 18th of June 2020 until IP completion day. And those words that need to be construed are acquiesced for a period of 5 years in the use of the earlier sign while being aware of such. Sorry, in the use of a later EU trademark in the relevant area whilst being aware of such use. And the application of that to the international registration in issue is applied by Article 189 on page 374. The relevant article is sub-article 2. If no refusal has been notified in accordance with Article 5.1 and 2 of the Madrid Protocol, such refusal has been withdrawn. The international registration of a mark designating the Union shall, from the date referred to in paragraph 1, have the same effect as the registration of a mark as an EU trademark.
And the effect of your submission is that we read if as meaning for so long as.
Yeah, if no refusal has been notified. Absolutely. And that interpretation is entirely consistent with the obligation under Article 4 of the Madrid Protocol. And then, as I turn to the Act, I can deal with both the Act and the point about Section 2.2 in one go. So we turn back to tab 19 in bundle 2.1. And the relevant section 48 on page 15. No, do it in the correct chronological order, I beg your pardon. I take you to, as I did before, to page 16 is section 54A that applies Schedule B, making provision for international trademarks. And then Schedule 2B applies to the marks in issue. Paragraph 1.1, a trademark which immediately before IP completion day is an international trademark which is protected in the European Union in accordance with Article 1892, which these marks are, is to be treated on or after IP completion day as if an application had been made and the trademark had been registered under this Act in respect of the same goods or services in respect of the international trademark is protected in the European Union. So at that point, the CTM stays with its acquiescence defence, if I'm correct, for the remaining territory of the European Union. And a new right is brought into existence in the United Kingdom that replaces what was previously protection provided by the EU trademark in its international form. That right is now subject to the rules under Schedule 2B, and you are right, it would be surprising if the law applicable to it, including the law of acquiescence, was different. My submission, it's the same. And we get that from paragraph 10A. The date of filing of an application for registration of a comparable trademark IR is the same date as the deemed date of registration of a comparable trademark at IR under paragraph 6. And paragraph 6, comparable trademark is deemed for the purpose of the Act to be registered as of A, where the protection in the European Union of the existing IR for from which compelled trademark derives resulted from a request for territorial extension under Article 3 ter 1, which it did, the date of registration of the existing IR-EU in accordance with Article 3.4, and that's Article 3.4 of the Madrid Protocol. So we get the same result there. And then we turn back to the effect of Section 48. Section 48 falls to be construed in accordance with the directive in the same way as the regulation, and the wording is of equivalent effect to the provision of the regulation we looked at. Where a proprietor of an other earlier right has acquiesced for a continuous period of 5 years in the use of a registered trademark in the United Kingdom, being aware of that use, there shall cease to be any entitlement on the basis of that earlier trademark or other right, A, to apply for a declaration that the registration of that later trademark is invalid, or B, to oppose the use of the later trademark in relation to the goods or services in relation to which it had been so used. The question of construction as to that use or such use is the same according to the same purposes which are set out in my submissions and gives rise to the same results. So if I'm right about that question of interpretation, the time had passed on the 18th of June 2020 and the acquisition of the acquiescence defence continues to apply. The only question then is, did presence of section 2.2 in the Act change that? My Lord Justice Arnold asked the question about section 2 of the 1938 Act. I gave a copy, what I've got is a copy of the 1938 Act and the commentary on it in the 8th edition of Curley, Mr. Blanco White's copy. And my learned friend had it at lunchtime. It provides that history, but it's exactly what your Lordship said.
Sounds helpful to me, so let's have a look.
May I?
Usher, would you be kind enough? Thank you.
There are 3 copies. I also, by the way, I think I said the passage in Morecambe trademarks was in the 5th edition. Also found it in the 1st edition in 1999. Well, you understood the point I was responding to. So the reason that I went to that particular edition of Curley is because the later editions had a footnote saying previous editions give a detailed explanation of the reasons for that section, and this is the last edition that has that detailed explanation in it. It's the second one after the 1938 Act came into force, and what it explains is that there was a line of case law that said that trademarks as such unregistered were protectable in English law, and the 1938 Act sought to distinguish those rights from registered trademarks whilst preserving the law of passing off. It later emerged during cases such as Burberry and Cording and so on, that in fact those references to trademarks in the old law were really a reference to the law of passing off. So you end up with a situation where the saving provision in the Trademarks Act that's designed to stop the Trademarks Act governing the law of passing off generally has to remain there, and if it wasn't included in the 1994 Act, there would then be the question of, well, what's the effect of that removal? So that's why it stays there. But then you have the points that I made in my skeleton argument, supplementary skeleton argument, dealing with the passing off point, which is
So it's the relevant passage at page 257. Middle of the page. So I was wrong to
Yes.
speculate that it went back to 1875. It goes back to
1905.
1905.
That was fine.
But declaratory of the existing law.
Yes, that's right. The only declaratory of the existing law is to be observed that one effect is that it's no defence that the defendant is registered as the proprietor, which he is using. But where this is the case, it is usually the plaintiff at the same time moved to rectify the register. So that's exactly the point. So that leaves the now understanding the purpose of the section and its history. When one turns to the construction of section 2.2, in my submission it doesn't override for the reason set out in paragraph 53 of my skeleton argument. It's wrong to characterise this defence as previously unknown or unsuspected. It was expressly referred to in the first edition of the Modern Law of Trademarks, a copy of which I've got here, and the wording is...
It's all right, we've now got that.
Yeah.
Thank you.
Did I hand up copies to everybody?
Yes, well, it certainly came to me.
Yes.
Yes.
Thank you.
And the construction advanced runs against the well-known statutory presumption that general provisions do not override specific provisions, and that is clear in an authority in the Court of Appeal, Venus,
Well,
and Martin.
that principle is not in dispute. What's in dispute is which is the specific and which is the general.
Well, that's very clear. Section from the history as well. Section 2.2 is the general, and that's because it's the provision of section 2.2 says no proceedings lie to prevent recovery of damages for infringement of an unregistered trademark. As such, notice it's been limited to prevent or recover damages, but nothing in this Act affects the law relevant to passing off. So that's a general provision about the interrelationship, but then the implementation of the directive in the Act is specific to the relationship between the registered, an earlier right, such as passing off, and a registered trademark, where there's a specific provision that provides for limitation by acquiescence and a coexistence regime which results from it, and then there's the point in relation to the 1989 directive, which has the recital about the purpose in it. It sets out the purpose of reasons of legal certainty, but not inequitably prejudicing the interest of the proprietor. Of course, that doesn't cover all the purposes, because what all of the case law does is it identifies a range of purposes behind the directive and this provision, which are consonant with the recital, not limited to just the words in the recital.
Mr. Single, I hesitate to interrupt, but two things. First of all, this is reply, not
Yes.
fresh submissions, and we've still got to deal with issues 4 and 5. And then
This is responding to issue 5.
this is specifically to issue 5. You're not
Yes.
elaborating further for your purposes of your reply.
So the point that I'm just clarifying is that my learned friend said that section 48(1)(a)
Yes.
was based on Article 9.1, and that section 48(1)(b) that he says is optional is based
The
on
optional as opposed to the
Article-
mandatory.
Article 9.2. That is incorrect. If you turn to page 75, the mandatory provision in Article 9.1 is in relation to acquiescence in relation to the use of a later trademark, and Article 9.2 is acquiescence in relation to an earlier right, and then the two limbs that are in Article 9.1 are applied mutatis mutandis. So that the suggestion that the effect on passing off by way of a defence is somehow optional, whereas the other isn't, is wrong. The optional nature is whether you implement the relationship with earlier rights at all, and the UK government decided to do that. And so then coming back to, so that's why I say Article 48 is the specific, and it becomes all the clearer that the principle set out in Venus and in volume 96 of Halsbury's Laws is consonant with the analysis provided in Morecambe, and it's also consonant with continuity between the EU regime and the UK regime, whether that's between UK marks and EU trademarks as they stood, or implementation of the directive, or now the position that we have, where a mark moves from the EU regime to the UK regime as a comparable mark. And Section 2.2 should not be construed to interfere with that, because there is specific provision in Section 48 that is designed to have a specific effect in relation to earlier rights expressly. So that's the answer in relation to the substance of the point of law in relation to passing on. So far as the other aspects of the position in relation to passing off, permission to appeal, I've explained in some detail why it would be unjust to grant permission to appeal on the basis that, well, the court's dealt with the same thing in relation to the registered mark.
Well, there's two different questions in play here, and I'm not sure that they've been clearly distinguished between them. So one is a fairly dry procedural question of whether permission to appeal is required or not, or whether it can be, the point can be run as a right under a respondent's notice. But then there's a separate point, which is regardless of whether permission to appeal is required or not, let's assume it is, but it's granted, just to put the hypothesis make the hypothesis clear. Then the question is this a new case being run on appeal, as to which we're into sing and daz territory? And although neither side have really analysed in that way, that's the effect of the arguments, because you say, yes, this is a case where the new case shouldn't be allowed to be run on appeal, to which there's two possible answers. One possible answer might be to say, well, actually, this case was run at first instance, and the fact that the judge didn't decide it doesn't alter that. And the other possible answer is, well, that can be dealt with by remitting.
So the sing and daz point applies to the amendment to paragraph 2A, which is issue 4, because that was never a pleaded issue. And on this front, on passing off, there was a passing off claim run.
Yeah.
The point is where you have an application for permission to amend the respondent's notice, which in fact requires permission to cross appeal as well, and those two permissions can be dealt with together. Both involve the exercise of a discretion when it's being raised at this time. And the point that I make is that the factual issues are different. The factual issue for...
I'm sorry to cut into your submissions, but I think we're slightly at cross purposes because you've just mentioned paragraph 2A, and I take your point. That raises different considerations, but that's going back to the question of when did acquiescence end, as opposed to the passing off claim, viewed as a passing off claim.
And we're dealing with the passing off claim at the moment.
Well, that's what I thought you were doing.
I'm not saying the passing off claim is a new claim raised on appeal. It's a cross appeal in relation to something the judge didn't decide.
Right.
And the distinction on the decision and on the facts is that the validity of the claimant's trademarks had to be determined on the question of normal and fair use of those marks across the specification. And what I point out in the skeleton is there is a series of factual points made in the defence and counterclaim as to why, as a matter of fact, there wasn't passing off. And the judge decided not to deal with those because there were all sorts of additional factual issues to determine. And not only did she decide not to do that shortly in the judgment, she was asked to make an order in relation to passing off at the form of order hearing, heard argument about that, and declined to do it. Now, in those circumstances, where the application to amend is brought in such a way as not to bring the factual material, the transcript and so on in front of this court to understand that distinction, we submit that it is unjust to grant permission to amend the respondent's notice to run the passing off revision point at this stage. Another point that was taken against us is that the section 48 defence in passing off was not pleaded, and I took you to paragraph 12.3, and it was pleaded. And then I've dealt with the effect of section 2.2, and in my written submissions I also dealt with the special nature of section 48 in paragraph 5.5, supplementary skeleton, as to the interpretation of section 48.1. And the point that Parliament...
So I'm sorry, but can I just go back over the point we were just dealing with and see if I've now understood a little more correctly the rival submissions. So this is the technical question of whether permission to appeal is needed, and then there's also the question of whether there should be a late amendment to the respondent's notice. I think I've now got those points, but where it all leads to, I think, is this question, which is this, assuming we get to this stage at all, is this court in a position to decide the passing off claim? And what you're saying is we're not. But is it your submission that we would be precluded from remitting?
It's not my submission that you're precluded from remitting. It's my submission that you should not give permission to amend the respondent's notice to decide to remit. And that's because I haven't had a fair hearing at this hearing to deal with all of these questions about the nature of the passing off claim that's brought, and it being said, well, all you need to know is that it is on the same factual basis. One effect of that submission is that permission to amend shouldn't be given. Second effect of that is that this court should not simply decide the passing off point against my clients. But as you'll have gathered, I say that it never arises because if I succeed on the appeal in section 48, then
Sure.
that gives the defence the possible.
Sure.
And then that only leaves me to deal with issue at 4, which is this point about the respondent's belief. And my learned friend made various submissions based on the judgment. There's one very key point that it's important for you to see.
Yes, but this is where we do get into the sing and dance point. So I think
Yes.
it might be helpful
Let's start with pleading.
let's look at what they're seeking to put before this court,
Yes.
which is in the court bundle at tab 3.2,
Yes.
and this is the paragraph 2A.
Yeah. So, paragraph 2A reads, that such letters, so the individual letters that were pleaded, 2 of which were pleaded, formed part of a commercial context whereby the claimant was actively seeking cessation of the defendant's use complained of, and reasonably believed that the defendant was ceasing such use. In particular, the claimant did not merely apply to invalidate the defendant's trademarks, but was engaged in negotiations with the defendants, including in person, to find a commercial resolution, as a result of which the claimant reasonably believed that the defendants were stopping the use complained of, and only issued proceedings when it became clear that the defendants were intending to continue the acts complained of.
Right, and this is what I was talking about earlier and got confused, which is, as I understand it, one of the things you say about this is a new case.
Yes.
Because there was no investigation of reasonable belief of cessation of use at first instance.
Absolutely, that's right. And this pleading, you can only work out what the factual detail is once you get to the skeleton argument. So,
I don't understand that, because the IPEC rules require you to plead all facts, matters and arguments.
Absolutely. And so no facts and arguments are pleaded at all in relation to that case in the IPEC. So one finds that in the re-amended reply in defence to counterclaim at tab 14. And it's in paragraph 16, in response to paragraph 12.4d. Defendant's ICE word mark was registered on the 25th of May 2016. The ICE Randall mark was registered on the 14th crossed through 15th of June 2016. The claimant first complained of the defendant's activities on the 26th of July 2019 by a cease and desist letter. Therefore, the period of alleged acquiescence terminated on that date, which is less than 5 years from the earliest date of an alleged knowledge of use of trademarks, and less than 5 years in the registration of the marks. Further, on the alternative, there's invalidity proceedings, which are no longer relevant. And then over the page, further, and or in the alternative, these proceedings were issued on the 24th of May 2021, being less than 5 years from the date of registration. And that's all that's pleaded. And then what my learned friend's application in support of the application to amend says is, but the kinds of things that have been summarised in that new paragraph 2A were introduced by way, or were argued by way of oral submission in closing, and that somehow I'm shut out from saying you can't run this point on appeal because I didn't complain about that amongst the many issues that had to be dealt with in this 2-day IPEC trial. My submission, that doesn't allow this point to be run on appeal, and it's unjust for permission to amend to be given to deal with it now. And then we move on to the point that I jumped ahead of myself on, which is even on that pleading you can't tell what the case is being put forward. You have to read my learned friend's skeleton argument to understand what negotiations are being spoken about.
Well, we have your detailed submissions in
And you
your
have my
supplementary skeleton argument.
In relation to that.
Now, anything else? Very conscious, Mr. Campbell's got to make his submissions.
Mr. Campbell's got to make his submissions. If I can just take a moment to take instructions. But I just wanted to make the point that what is said there just skates over the fact that in fact there was one meeting where there was discussions and there were these long gaps between the letters. When you read the email in December 2019, you can see there's complaint about activity. That's after the discussions. When you read the letter in December 2020, you can see there's complaint about the activity. So in fact what you have is periods of delay and inaction when activity on the part of my client is being complained of, not what is asserted about reasonable belief. But then I do need to show you the one sentence in the judgment.
Paragraph?
Paragraph 50, page 115, refers to the pre-penultimate line. After referring to high-tech, see the discussion about continuous use of plume, which is not relevant for the purposes of this case.
Thank you.
So the judge didn't think she was dealing with gaps in use or anything like that as part of the acquiescence defence. You've got my submissions already on the gaps in the period. May I just take instructions for a second?
Anything else, Richard? Thank you very much. Yes, Mr. Campbell.
Thank you, my lady. A few points, some of which are just giving references. The first point is I forgot to answer a question from Lord Justice Nugee about the criminal provision about falsely representing its register, section 95.
91.
95. And oddly enough, all the reproductions don't have that. There we go. Secondly, a question which occurred to me is, how much of the Madrid material actually matters and to what? Now, I accept it goes to my second respondent's notice point. We had that discussion with Lord Justice Arnold. It's not just my submission, but also my learned friend's ground of appeal, skeleton argument, and chronology. It doesn't matter to either of his grounds of appeal, not even the second. And my lawyers might have thought that the date of 24th of May 2015 might have had some prominence, but it's not in the grounds of appeal at Core Bundle 2, page 14, or at page 20. It's not in my learned friend's skeleton argument, Core Bundle 4, paragraph 50, subsection 5 and 51, or Core Bundle 6, page 93, which is a chronology. Nothing in any of these about the importance. It always was simply the correct date is the June 2015 one. That's always been his case. The 24th of May point has just come out in all submissions. Now the next point is section. Yes, if my friend wants me to go to it, I'll go to it. I wasn't planning to, but Core Bundle page 16. Core Bundle page 16 in tab 2. Go back to page 15. This paragraph 3. This appeal raises two important issues of law in relation to forever. And then at number 2 on the next page, whether for the purpose of section 48 of the Act, D1's 2015 trademarks have been registered since 18th of June 2015, dating the date of the registration at WIPO in accordance with Article 3.4 Madrid Protocol, as the appellants contend. So that was their contention. Or on 24th of May 2016 and 18th of June 2016, the claimant contended at trial.
So that would be our contention. In fact, it wasn't even our contention, but my learned friend's contention was 18th of June 2015. And I'll just show, actually the chronology is quite a good way of doing that. If one looks at the chronology at page 93 in tab 6, notwithstanding all the blue type which my learned friend's clients inserted into this, there's no suggestion that 24th of May 2016 has got any significance at all.
Thank you.
Okay, now the next point was Leonard Friend's point at section 2.2. He went through the historic origin of this back to previous statutes. In my submission, it's simply immaterial why it was in previous statutes. The reason it was in the 1930 Act for reason X doesn't mean that it was in the 1994 Act for the same reason, because the 1994 Act was for a completely different purpose. It was the new departure. And one still has to give effect to these, to the wording that one sees there. Leonard Friend made a point. He corrected something I'd said about Article 9.2, the optional point about earlier right at all. You're right to correct me about that. I was wrong about that. But my submission about Section 48 remains that it's possible to interpret statutory acquiescence as referring to rights other than passing off, because that's the rights you're losing by virtue of Section 48. Leonard Friend said that the judge below was asked at an oral hearing to make an order for passing off and declined to do so. I don't believe anything really turns on that, because the fact is there's no order about it, and the judge said she wasn't dealing with it. But as I said in my oral submissions earlier, my Leonard Friend's appellant's notice, sealed notice, when he says what order he's asking for, he is actually asking for an order dismissing the claimant's claims for passing off. So they can hardly be already dismissed if he's asking for that. So far as the paragraph 2A is concerned of the respondent's notice, first of all, he said it was a late amendment to the respondent's notice. Well, the application to amend the respondent's notice was notified to them on the 19th of June 2023, so that's 5 months ago, almost. The reference for that would be supplemental tab 30, page 177. I don't believe my Leonard Friend ever identified any specific prejudice to his clients if this court does decide passing off. If he did identify any specific prejudice, I don't recall him doing so.
He did on the 2A point, not necessarily on the passing off. And one's got to distinguish them. I got confused earlier. As far as paragraph 2A specifically is concerned, he says, well, that just wasn't investigated at trial because it was never.
Yes, I think we've been ships passing a night about paragraph 2A, because Leonard Friend thinks it's a new case, and we've consistently say no, it's just a way of characterising the existing case.
Well,
so why do you need it?
Show us where it's pleaded.
Oh, it's not pleaded in those terms.
But show us why, if it's simply putting your case in a different way, and you've had oral submissions in support of your case, why do you need it in that case?
Oh, well, all I wanted to get in, and I think I did do this, was the letters, which I took the court to, my Leonard Friend took the court to as well, and the judge's finding about the negotiating tactic and the 20 cessation of business. If I don't need 2A to do that.
Maybe you're not running a point that we think you are running, in which case you can tell us. But on the face of 2A, you are running a point about your client's reasonable belief in cessation of activities.
Yes. Now, I can clarify that. I'm not running that particular point.
Right.
All I'm running is all the points I said earlier about the letters the judge is finding about negotiating tactic and the 2010 cessation. At no point did I actually refer to my client's subjective belief, because I always said objectively it was reasonable not to commence proceedings at that point because of the negotiating tactic. Objectively, it was not reasonable not unreasonable rather, to commence proceedings at the later point because of the total cessation. And I did phrase it as
apologise, Mr. Campbell. I'm sure it's my fault. I'm now deeply confused. I'm grateful for the clarification that you're not running the point about reasonable belief in cessation of activities. But you do still seem to be trying to rely upon more than just the text of the letters. And that leads to two queries in my mind. first of all, what more are you trying to rely upon other than the text of the letters? And secondly, why should you be able to rely upon more when they were that more was never pleaded?
Well, the reason I'm saying the negotiating tactic wasn't pleaded because that was a finding of fact at trial. I was relying on the judge's finding of fact to that effect, not anything we pleaded.
That seems to be an argument to the effect that the way you run litigation is to wait for the judge to make a finding of fact and then tell the other side you rely on.
Well, plainly I can't do that.
Right.
But on the other hand, Arnold doesn't have a point about in the Intellectual Property Enterprise Court, you do plead facts, matters and arguments. I understand that. But the procedure which was adopted in this case was that they didn't just restrict themselves to the pleading because the evidence went further. That's why the judge had to decide all these things. The meeting at Las Vegas, a breakfast meeting in 2019, people didn't take the point that wasn't pleaded. It was the subject of evidence and cross-examination and findings. And similarly, the point about the total cessation of trade in 2020. It's true that wasn't pleaded, but that was in evidence and the subject of submissions. And the points I'm making, they were made in closing submissions. In the skeleton argument, I do give my reference. All the points I'm saying were made in closing submissions. And the point wasn't taken then, oh, that's not been pleaded. I'll just give my lady, my lords, the reference to where we say that the skeleton, and then I'll sit down. Find out there are notes in
Your issues 3 and 4 start at your paragraph 63.
Yes, that's the, actually it's paragraph 65.
Yes.
And 66. I'm grateful to my lady. What page is that? It's a point of correction rather than anything else. It's core bundle tab 14. Re-amended reply and defence to counterclaim. Paragraph 16. As to paragraph 12.4d, the first defendant's ICE word mark was registered on 25th of May 2016. My little friend's just wrong to say that we ever said it was registered on 24th of May 2016. It was always the 25th that we said.
Yeah, and the second one you even corrected the date.
Yes.
Yes. So, thank you very much to my lady, my lords, for their patience.
Any more questions? Any more questions? Thank you.
Thank you very much.
Now, I don't suppose you want anything in reply, further reply, reply to the reply.
I don't think I'm entitled.
No, it was just when you originally set out how you're going to tackle it, you had a rather more firm structure about how we're going to deal with issues for you.
I think we did the structure that we said we would do.
Fine.
I'm not sure my learned friend picking up points at the end there necessarily stay to just the two issues, but I don't need to.
No, I don't think so. Well, can I thank everyone very much indeed. I'm very conscious that we've had an enormous amount to get through. in the day and a half, and we're very grateful for all the written material which helped us to do that. And we won't be surprised to hear, reserve our judgments. I can't tell you precisely when they will be handed down. You'll be sent a draft in the normal way. Might I remind you and those behind you, junior counsel who always get landed with this, of the importance of observing the embargo on the top of the draft judgments and ensuring that we get a proper list. I'm very conscious of any commercially sensitive issues in any of these cases. Normal thing, typographical errors, minor questions of fact, not an opportunity to really argue, please. I'd hope you'll be able to ultimately agree in order. Anything else that you can't agree, we'll deal with in writing. So if I can thank you all very much indeed. I don't know if I've got behind you the people that prepared the bundles, but if so, may I thank you very much. Certainly for my part, they were an example to everyone, and I'm extremely grateful. And I'm sorry if you were cursing us all when you realised it had to be single page and not double page. Thank you all very much indeed.
Rise, disabled.